Y'all ready? Okay, the February 4th session of the Coppell Board of Adjustments is now in session. Item number 2 is a work session. We're waiting on Bob Hager.
There he is.
And there he is.
Bob?
He's frozen.
Yeah, he's
Bob?
frozen.
Bob, are you cold? Bob?
There he is.
Bob, you're on mute.
Real quick, Mark, I just wanted to let you know I'm going to have to exit the meeting at about 7:30 and then come back. I'm double booked, and I've got to go to something else. But I'll come back if y'all are still.
Okay. Well, we have a work session going on now till 7. So we'll see you soon.
I'll be here through that. I don't have to depart until 7:30, so I don't know how much longer it'll take the rest of what we're doing after the work session. So we may finish before I need to leave, but I just wanted to put that out there in case we're not done.
Sounds good. All right. So can we get a roll call, please? Let everybody know who's here and who's going to be active. Okay, so Kimmy, you're here?
Yes, sir.
Michelle Anderson? Not here.
Jill Anderson's there.
Where?
Second row,
Hi.
second
I'm
box.
right here.
Oh, there you go. I see it. Okay, there you are.
Sorry, I was muted.
Laura Ketchum?
I'm here.
Okay, me. And I guess, Rhett, you'll sit in tonight for me, please?
Absolutely. My pleasure.
Okay, and you're here. Okay. Item number 2, work session. Mr. Hager is going to give us a... Where'd he go?
He probably
Sure.
jumped off. We're going to try to jump back on. He was having some issues.
Yeah, I think you might have a bad connection. I'm going to send him the information for the audio just over phone, so if he can dial in that way.
Okay. So I'm not the only one, huh?
No.
I feel better. Okay, we're going to wait a little bit for the work session.
And Suzanne was on earlier, but she may have had to step away.
There she is.
There you are. Hi.
How are you?
Are you in the attic?
Doing great.
No.
I'm just kidding. So anyway, so we're waiting on, I guess, the work session to begin. I have no agenda personally. We're waiting on Bob. There he is. Okay, Bob, you're on.
Okay, thank you, Mark.
And you're off again.
Oh, no.
Regarding the Board of Adjustment. And I know many of you have already heard this presentation, so bear with us. And we've had the benefit of recently having a couple of hearings, so most of this should be very familiar to you. We will visit with you later about a new job that the City Council has given you, which may cause us to meet a little more often than we normally would have, but we'll go ahead with our kind of routine training and then talk about the short-term rental and what your role will be in the administering of that ordinance as we move forward. And next slide. I don't know, Cammie, were they able to receive a copy of the presentation?
No, I didn't send one, but I can do that right now.
Yeah, you can send it to them even afterwards so they have it for a reference point. It's whatever they would desire. The board is obviously created by state law, and it's contained in Chapter 211 of the Texas Local Government Code. And the purpose of the board is to hear appeals on certain activities in the enforcement of the zoning ordinance and to interpret and or grant special exceptions under the zoning ordinance, or to hear appeals from determinations of the building official in the administration of the building codes and the zoning ordinance of the city. You, in this capacity, you act in what the lawyers like to refer to as a quasi-judicial role. So you actually act as judges in these cases, not as administrative officials or legislative officials, and you apply the law as it's written, and then you obviously make a determination of facts and then make decisions based on that, much like a judge. Next slide. Our authority, again, emanates from Chapter 211 of the Local Government Code, as well as Article 41 of the Coppell Ordinances, which is a zoning ordinance that applies to the Board of Adjustment. Next slide. One of the things that are the three things that you kind of statutorily and by ordinance routinely handle are these concepts of a variance, which I know you have done, and we have had some occasions to do that. One of the things at memory is to determine a termination date for a non-conforming use. And then occasionally we have the administrative official enforcement attorney when we get together and you act as a judge is to do so in terms of granting variances. And Mr. Chairman, if anyone's got questions or want to talk about any of these while it's on their mind, please feel free to interrupt or entertain a question, because I'd rather answer your questions than instead of me talking for 10 or 15 minutes straight.
Thanks.
Statutorily, the board consists of 5 members. We have 4 alternates that we are entitled, or the council is entitled to appoint. You're appointed by the city council. And we are required to have at least 4 members, either 4 regular members or a combination of alternates and regular members to at least have 4 people. When we hear variance cases and to make decisions under the zoning ordinance, for the reason that it requires at least an affirmative vote of 4 people to either grant a variance, to administer or make an interpretation of the administrative enforcement of the zoning ordinance, or to make a determination for non-conforming uses. And that's that 75% to authorize specific cases for that 75%. We can go and actually skip through 2 and let's go right to the variance. So I need 2 slides. Go on to the next one, please. The waiver of the strict requirements of the zoning ordinance, and we talk about variances. Variances is defined as relief from or variation of the provisions of the regulations, which are the zoning regulations, other than use. You can't vary a use. If it's only for residential purposes, you can't grant a commercial use for those premises. You can only make interpretations regarding things like setbacks, height, separation, accessory buildings, and the like, not make a decision on use.
Hey, Bob.
Yeah.
Bob, it's Laura Ketchum. We have done parking variances for commercial property. Is that included?
There's a variance of the interpretation of the parking ordinance that would be appropriate, but not not that, because that's not a use. You would be interpreting of things like the number or how you count them, or you might reduce the amount of parking that's
thank you.
Because it's a drive-through restaurant or certain facts there because of the configuration of the lot.
Okay, thank you.
That's a little bit different than the distinction where we do exceptions. We do not have many provisions in our zoning ordinance that require special exceptions, and there's somewhat of an acronym, as they're not used very often because most cities have what they call planned development so that they can tailor a use or a set of uses, and all the regulations regarding height, setback, parking, and other requirements are tailored to the size of the property, the uniqueness of the property. So we very rarely have what we would generally call a granting of a special exception. The special exception is different from a variance, although the effect may be the same. It may say something to the effect that we would allow a fence higher than 8 feet, which is our maximum height of a fence, if one, the property was adjacent to a 3-story building, was the building was only less than 20 feet from the property line, and would have a various number of criteria. Your job on that special exception would be to make sure that that criteria exists in order for the special exception to be granted. It's a more mechanical application of the facts, whereas a variance is a little more and obviously tricky because it takes some interpretation of what the uniqueness of the property is, where a special exception does not necessarily have to have uniqueness, but it does have to have a set of circumstances that you would have to make fact finding in order to grant the exception. And if that's not confusing, don't feel bad, because there's very few judges that understand the difference either. So do you have any questions about special exceptions or variances? I know variances are really tricky, and they're really, it's a concept you almost have to have a case in front of you to really understand what we're talking about in variances. If you'll recall the Ansari case, which
I was going to ask about that.
A little over, no, it's been almost 2 years now. That case involved a requirement that that the property owner was attempting to build an extension by putting an awning and a structure, pad and some porting beams and an awning into the side yard setback. And they were attempting to say that their property, that they were entitled to a variance, because normally that structure would not be allowed to be constructed into the side yard. The board in that case found that there wasn't any special circumstances as to the size of the property, the configuration of the property, and it didn't meet the uniqueness standard, and therefore could not be granted a variance, and you denied that variance. Every house in that subdivision was on the same size lot, had the same size setback, and had the same kind of constraints that they did, so that they couldn't show or demonstrate the kind of uniqueness that would qualify for a hardship in that case. That case was tried, was appealed by the Ansaris, and then tried by the judge, Goldstein, and your decision was upheld, being the appropriate decision. So the Ansaris did not get to build that structure in the side yard of their home. Some of the hallmarks or some of the evidence that you would hear when you hear a variance case and make this determination of hardship is the hardship self-imposed? In that case, they bought the house knowing of the side yard setbacks, so that there was no, what they wanted to do was a self-imposed hardship, because they wanted to basically expand the size of their home. There was nothing in terms of the size of the property, the shape of the property, or the topography of the lot or tract of land in question that was either unique or had special circumstances which made their situation any different than anybody else in the neighborhood, and therefore did not meet the undue hardship standard. They claimed that there was a financial hardship in this case, but that wasn't, and I believe they also had made some claims that one of their children needed that shade structure in order to play outside. On that, that was not grounds to create an undue hardship in that case, and so they didn't meet the uniqueness standards. And so those were the primary challenges that are that the evidence has to be adduced to make a determination of whether a variance could be granted.
I see a lot
I've got
of times.
that formal definition. Yeah. Do you have any questions?
I was just going to make a little comment that most of the times that we hear cases on whether or not there's a hardship, the evidence is presented all lends towards personal hardship and not a property hardship. And there has to be a distinction between the two. And we all need to understand what the distinction is. And, but personal, everybody has.
It's because of the condition of the property, not uniqueness in terms of the owner's desires or special circumstances the owner may have for the property, which is to the chairman's point that would be a personal hardship, not a hardship that would be due as a result of a property hardship. Some of the cases on property hardship, if the city were to exercise its eminent domain authority and widen the street, and then thereby taking part of the side yard or the rear yard of a person's property, then that would constitute a hardship for that property owner. And that property is because some act of the municipality or the city or the state has taken their property from them. So it was not a circumstance that they created, but it was much like maybe an act of nature. One of the things that could be a hardship is someone that owns property along a river or stream, and that there's been erosion which may change the channeling of that creek or tributary in such a way as it would take part of their property which was previously not in the creek, but now may be in the creek. And so they might have a hardship as it goes to a rear yard or a side yard setback. That's a hardship that was created by someone else, not by themselves, although they bought the property near that creek. I think that would still constitute uniqueness on that person. There's a famous case where there was what I call a heritage tree. The tree was basically about 140 years old, and in order for the person to make the improvement on their property, the tree would have to have been cut down, but for the fact they needed some relief on the side yard setback. In that case, the court found that was an unnecessary hardship. It was something beyond the control of the property owner to save that specimen tree, and it made the property sufficiently unique that a variance was appropriate. So the court would, take those things into consideration. If you remember back in the Ansari case, we had none of those elements of taking or there had been a change on the street or there was anything particularly unique about those properties. That property was over on Deer Run subdivision. You're familiar with that, on Coppell, off Coppell Road. They're townhomes, and each one of those lots are the same size and almost a absolute, rectangle for each one of those lots, but all those lots are the same size. So there was nothing unique about the Ansari's property as it related to its neighbors or its adjacency or the circumstances of the house itself. We can slip on to some more examples of variances, if you would. Next slide, please.
I'd like to go ask one quick question, Bob.
Sure.
We have had more than one case that is citing a medical issue to build something, or like the Ansari case. You're saying that would be considered a personal hardship?
Yes.
Okay. That's helpful.
There are some circumstances. I have seen some federal litigation that involved the Americans with Disabilities Act and the Fair Housing Act. And some of the circumstances for those kinds of cases, they were personal in nature, and they were ADA accommodations. They were not variance candidates.
Okay.
So
That's
if we
helpful.
found, if for example, if I became incapacitated and I needed to have a ramp in order to accommodate a ramp for a wheelchair, that would be something that the building official might be able to, quote, accommodate under the ADA because of my circumstances. It wouldn't be grounds to grant a variance. So those are things that we would address with Ms. Arnold's department if there were circumstances. I have written those exceptions, and once the disability, just say if I had a temporary disability and I was in a wheelchair, that once I became, I no longer needed the wheelchair, then the ramp would have to be removed. And so that's in order to protect the integrity of the building code and of our side yard and front yard setbacks, but it accommodates the Americans with Disability Act and a fair housing question as well. Because a person potentially, if you could not have a ramp onto a house, it would deny housing to a certain segment of our society, which those characteristics could not be helped. They need to have special physical accessories to help them be able to obtain housing. So there's a way to address those issues if they can reasonably be addressed.
That's really helpful. Thank you.
Mm-hmm. That might get into an interpretation. You might get an interpretive case whether or not the person had the kind of disability that, in this case, Ms. Arnold would want to grant that special circumstance to a person. So you might get those cases, but through another avenue, if you will, other than a variance avenue. Let's go with, so we don't spend too much time on variances. Is there any other question that you have about variances? Invariably, when we get to a variance case, you'll have forgotten most of this if you haven't actually sat through one of these, and we will give you another primer before to do that on these things. And if you would like a copy of the presentation, if you don't have one, I've sent it to Ms. McGee, and she can send that to you. So non-conforming uses and structures, go to the next slide. Keep going, please. Keep going. Okay, here we are, non-conforming uses, which means that there's a use, for example, we really don't have many of them in Coppell because we're new. What might be a non-conforming use is if you've been in Dallas or been in some of other older, smaller, what I call first tier suburbs of Dallas, there are many traditional, and in Carrollton there's some of this, where they have homes in the old downtown district, but they've now become boutique shops. They may have other uses for those homes, and so the homes then become non-conforming because the city has now changed the zoning ordinance to expand a commercial, retail, or office to utilize those homes, so the homes then become non-conforming uses. Where we would get involved is if we had a situation, most cities that have non-conforming uses in their ordinance say that you can keep that home and live in that home so long as it is continuously being used as a home. And it doesn't have to be the same owner, but it just has to be continuously used as a home. If it is abandoned for usually 6 months or more, then you lose your non-conforming right, and then the use or the structure would then have to come into compliance with the change in the zoning ordinance that made it non-conforming. So you might be asked to interpret what the date of the nonconformity, when it began, has it been vacated for 6 months or more, or has it been continuously used for 6 months, or been continuously used without any interruption? So you would make a fact-finding determination of the date of its nonconformity, what the use was being made of the property, and whether or not the property quit being used for its non-conforming use, and therefore it loses its non-conformity. The city in Texas, we also allow non-conforming uses to be what they call amateurized. And what that means is you can lose your non-conformity as long as the city does not terminate that non-conformity so as to amount to a taking of property without due process. So if I have bought the property and have lived in that, I'll use the houses, and I'll use an actual example. In the 1940s, a meat packing plant was built in Kaufman, Texas, and it's about 5 blocks from downtown Kaufman. And that meat packing plant was continuously operated for a number of years. It became non-conforming in 1980 when the city changed its zoning ordinance. And so it was continuously being used as a meat packing plant. It was sold to a Belgian concern, and they determined instead of slaughtering pigs and beef, they were going to slaughter horses. Yeah. And we're going to package this horse meat up for human consumption and send it to Europe, because apparently, as many of you know, in Europe, they eat horse meat, and it's used. So if you go to McDonald's, you might be surprised if you go to McDonald's in Paris. And I only say that is because I went to Chili's and had a hamburger off the Champs-Élysées, and I'm not quite sure that it wasn't trigger. But anyhow, so the city, the mayor, and became concerned about this horse rendering plant, and so they asked us to amateurize that non-conforming use. And so we brought a amateurization case against the meatpacking company to end its non-conforming use of that facility. And so what that really entailed was I had to determine the date of its non-conformity. I had to determine the investment that the Belgians had made in buying the non-conforming facility. And then what I did was, by using a CPA and an actuary, find out what the recoupment would have been for their investment. So the whole process was a hearing basically over how long had they owned the facility, and had they got the benefit of their investment, and did they being made whole, and therefore did not take anything away from them by amateurizing that non-conforming use. And if there was value, then the city would have to pay that value in order to end its nonconformity or allow that nonconformity to exist for a time into the future until the date they receive the benefit of their bargain, and the amortization would have ended in zero. So we went through that process, and thankfully they had owned the facility long enough. They had recouped their investment to the date of the hearing. And so in that case, the board found that the amortization period had been 25 years. They'd received the benefit of their investment, and that no monies were due to the facility and the Belgian concern, and ordered the termination of the non-conforming use. And we got sued and we won. And if you go to Kaufman, the facility's still there and it's not being used. So that's what a non-conforming, that's how that process would work. I would think that we are probably in Coppell, since we don't have anything, and you'll see this mostly where there's things like factories. Dallas used this process to get rid of the lead smelting factory. If you've been around long enough, back in the 1980s, city of Frisco threatened to use this type of process to get rid of a long-standing battery reclamation facility in Frisco, if you can imagine that. And that has been fairly recent. So hopefully we won't see that kind of thing here, but potentially it could be on a much smaller scale come into play. If you'll go through, Cammie, to 2 or 3 more slides till we get appeals of official. There you go. Thank you. This is last statutory provision which you have the authority to do, and this is basically to interpret what the, in most cases, the building official interpretation of the building code or the zoning official, and in which cases is our building official for these purposes, how they interpret the zoning ordinance to apply a potential violation or an interpretation of the building code. And so this is very rarely, it has happened. I think it's been a while since we've actually done this, but there's been an interpretation of whether this process or Y process or this product is approved or this product is not approved in interpreting the building code. In most cases, those things get worked out through the building code or through some kind of administrative agreement between us and the affected party so that you don't hear those cases. But if it does, the building official will present the case on why a certain material is the appropriate material for this, or his or her interpretation is the correct one. The affected party will have the ability to present evidence and argument in their favor, and you vote to either uphold the administrative officer or to uphold the interpretation of the citizen, developer, or builder. There are some, go to the next slide. Real quickly, the procedures for the appeals to the board. The aggrieved party, the city official, must file with the city official a written notice of appeal to the BOA. The official within 15 days have to make that decision. If an appeal is filed, the appeal stays all proceedings if there's enforcement proceedings until such time as the city or until the board holds that public hearing. If they then appeal to the court, your decision is stayed until such time as the court hears the case. Your job, next slide. Normally what we do is you act by order which all courts do, and so you act like a court. So you enter an order to either reverse or affirm, whole and in part. You can actually make modifications or make conditional grants of a variance to a party. And your conditions I guess modifications is the word I'm looking for, to a particular grant is appropriate for you to enter that in the order. You may order a variance for a period of time. Where, for example, we might allow someone to put up an extra large fence, and you might grant that variance, but it's conditioned on whatever the conditions were that convinced you to thought you needed to issue that variance. When those conditions were abated, then the fence would have to be reduced back to its 8-foot size. So, for example, if your house backed up to, say, Coppell High School, and there was a construction project going on, and so and there were workers who could look into your backyard, and a homeowner may want a height variance for a fence. And I'm not saying we can do this. I'm just showing you an example of what I'm trying to say. You might allow that variance in my example, the fence to be built at 12 feet, but once the construction was done, then the fence would have to be returned to 8 foot, which is the maximum height. So that would be an example of how you would tailor any order that you would make to a condition. So when that condition is abated, then your decision, the variance would in effect go away. Obviously, next slide. Anybody that is aggrieved from a decision of the board has the right to file this fancy writ of certiorari with the District Court of Dallas County, seeking to overturn, like the Ansaris did. Then a copy of all the evidence and your vote and your order become, quote, the original papers of your proceedings, and they are certified and sent to the district court for them to then review your decision based on whether or not you've abused your discretion. So if there's generally, what that means is if there's evidence in those original papers, that record, which supports your decision to grant or deny the variance, then the court in all likelihood will uphold that decision. If you were to make a decision that the building official still did not agree with the board, the city has the right to appeal your decision as well. I don't recall that that's ever happened in Coppell, but it has happened, I know, in Dallas on a number of occasions, having handled some Board of Adjustment cases for private citizens when I was a very young lawyer. Next slide. And this is just real brief and real quick. We have a great chairman who's served for a long time, so we're blessed with that. But the role of the chairman acts as the presiding officer of these panel of judges, the 5 of you, when you set. They ensure that whatever rules are imposed to conduct any hearing or proceeding, that they are followed, that our chairperson tries to maintain the dignity of the meeting so that people don't talk over one another, only talk when they've been recognized by the chair, and for any witnesses or people that appear, that they do so after the chair calls on them. They call our meeting to order. They help us comply with the Open Meetings Act by only discussing the matters that are on the agenda, and then they obviously engage the rest of you as board members to make appropriate motions and to comment on any case that comes before them. And of course, they have the opportunity to allow citizens to comment as required by the Open Meetings Act. Next slide. We also, and much of what we do is we have public hearings, and these like mini trials, we like them to present evidence. As you all know, anyone that speaks before you on any case that's before you should be sworn in, because you have the right to you must rely on the information they give to you. So they take an oath to tell us the truth, or at least their perception of the truth. We always like to try to start promptly as the agenda calls for, because we have witnesses and other people, as well as try to utilize your time in an efficient manner, and conduct an orderly process in conformance with the rules to maintain some decorum in order to ensure that we give both our city staff and affected citizens the full weight of the law. So you always weigh the evidence. As if you were ever a juror, you will be told, and you're acting kind of as a court and jury in this case, it's not always the number of witnesses, it's the quality of the information that's brought to you. It's the credibility of the people that testify before you. And it's not always about how many people I can bring or how many people the citizen can bring, but it's the quality of the information, because you should make a decision only based on the evidence that's brought before you, and you alone determine the credibility of all the evidence, whether it's testimony, a video, a picture, or a written document. And with that, I'll be happy to answer any questions.
I thought it was very thorough. Thank you.
Oh, you're welcome. And like I said, you're going to have a new job here, at least potentially in the future, and we'll talk about that a little bit. And I'm going to let you give me some homework. One of the things that we have done is we passed a order when we started the Ansari case to show an order of conducting our business. And so when we get to the STR stuff, I will ask you if you would like for me to draw up rules for those hearings as well, and then I'll give them to Ms. McGee, and she can present those to you at a future meeting for you to adopt, change and adopt, however you want to do it. So thank you.
Thanks, Bob.
Mm-hmm.
All right, are we ready to go on to item number 4, citizens' appearance? Do we have any citizens? No.
Mr. Chairman, we do not.
Okay, since we don't have any citizens, we'll go on to item number 5, approval of the February 6, 2020 minutes. Has it really been a year since we've been here? But, okay, I'll entertain a motion. Does everybody had a chance to look at the minutes?
I move to approve the minutes of the February 6, 2020 meeting.
Okay, I have a motion to approve. Do I have a second?
Laura say she'll second, but I didn't hear.
Laura, unmute.
Unmute, sorry. I'll second.
Okay,
Unmuted.
got a second by Ms. Ketchum. Okay, I'll do a roll call vote on that since we can't raise our hands too easily. Okay, Kimmy, yay or nay?
Yay.
Ms. Anderson?
Yay.
Laura Ketchum?
Yes, yay.
And myself, yay. So the minutes are etched in stone. Okay, election of officers. We've come up to that time again. So I believe we have Kimmy, you're the vice chairman, right?
No, Michelle is the vice chairman.
Michelle. So there you are. I usually have my cheat sheets on the paper. Okay. Okay. For vice, anybody else want to run for vice chairman, or do you like your job there, Michelle?
I'm good with it.
Anybody I need a nomination?
I'll nominate Michelle.
Any seconds?
I'll second.
Okay, all in favor of Michelle being vice chairman again? I'm gonna, Ms. Grubb?
Yay.
Ms. Ketchum?
Yay.
Mr. Hickey?
Yay.
Yay for me, and Michelle?
Yay.
Okay, so unanimous. Okay, chairman. I would like to run for chairman again. Somebody like to...
Are you nominating yourself? If so, I'll second you.
No, I'm just asking for a nomination, actually.
Then I'll nominate you, Mark.
And
Thank you.
I'll second the nomination.
Okay. I'll go ahead. Ms. Grubb, vote.
Yay.
Ms. Anderson?
Yay.
Ms. Ketchum?
Yay.
Mr. Hickey?
Yay.
And I'll go yay too. So thank you all for your confidence. We also need a new regular member. And I've got, Rhett, you want to be a regular member?
Absolutely. I love that.
Okay.
I'll nominate Rhett as a regular member.
I'll
Okay.
second
We
that
also-
nomination.
Okay. Mr. Smith wanted very bad to, but he couldn't be here today. So when you snooze, you lose, I guess. Anyway, I'll entertain votes. All in favor of Mr. Hickey being a regular member? Ms. Grubb,
Yay.
Ms.
Yay.
Anderson, Ms. Ketchum,
Yay.
Mr. Hickey,
Yay.
and me. Okay, so it's unanimous. Welcome on board, Mr. Hickey.
Thank you, sir.
All right, now on to item number 7. That was item number 7. Item number 6 and 7 are all done. Item number 8, the Str Appeal Process. I think Mr. Hager was going to, I think he kind of touched on it a little bit. Are we going to have any more?
Yeah, I touched on it a little bit, but Mr. Raheel, who is our major domo of short-term rentals, is going to do a presentation that he made to council. We're going to go through the ordinance and let Louis educate us about short-term rentals, and then I will talk about procedure when Mr. Raheel is done. Thank you.
Okay.
Thank you, Mr. Sherman. It's my pleasure to be here tonight to talk a little bit about short-term rental. The reason we are here tonight is because we recently updated our short-term rental, and we have given the board the ability to appeal the process if we revoked a permit. But before we get to that point, let me tell you exactly how we got here. Next slide, please. In April 2018, we started to get requests from a group of our residents asking us to have the ability to use their home for short-term rental. At the same time, we started getting concerns from other residents about this new phenomenon called short-term rental. So we went to council, and we asked council 3 questions. The main thing, what would you like us to do? Would you like us to regulate it, prohibit it, or basically just let it be? They gave us their desire that we need to go back to the drawing board and regulate short-term rental. Next slide.
Mr. Rawl, can I interrupt you just for a second real
Sure.
quick? By short-term, are you talking about things like Airbnb and stuff like that?
Yes, sir.
Yes.
Okay, thank you.
Thank you. So and anytime anybody has a question, please feel free to stop me and let me know. So we just, because I want to give you the most clarity that I can. And by asking question, I think we can get there. In May 2018, we went back to council and we proposed to council few regulation that we learned by talking to both sides of the equation, by people who wants to rent their home and people who want to protect their home from short-term rental. Next slide. And in June 2018, the City of Coppell Council adopted the first short-term rental ordinance that provided a balance between the desire of the homeowner to rent their home and the other homeowners to protect their properties from short-term rental. Next slide. And since that day, we went to council year after year to update our ordinances, because every year the short-term rental Airbnb and other platforms are changing the rules. So we always want to go back and keep updating our short-term rentals to make sure we are meeting the needs of our residents. And we'll give you a little bit status of our short-term rental as of today. We have 11 short-term rental properties in Coppell. Last year, we have about 10 complaints in the last 12 months. We collected with hotel occupancy tax about $11,000 in 2019, $11,000 in 2020. Next slide, please. So when we updated our ordinance this year, we had three things in mind, three improvements that we wanted to bring to the table. We wanted to improve our enforcement process, we wanted to improve our registration requirement, and we wanted to improve our neighborhood outreach. How did we improve those three things? Next slide, please. Our typical enforcement case when it comes to short-term rental is this. We hear a complaint, we open a case, one of our officers will go investigate the complaint. That could be a code officer or could be a police officer. It depends what time they call. We contact the property owner, and then 99% of the time we get compliance. If we don't get compliance, we go to what we call the second tier of enforcement. We send a courtesy notice, we wait 7 days, we send another final notice before we issue a citation. This is a great process, but the big challenge is this. A lot of complaints stop at compliance. For example, you have this loud noise, police officer go, right, stop the noise. Next week, the homeowner could do exact same thing. For that reason, we wanted to improve the process. Even though it doesn't go to the second tier, we needed a system that start counting those violations as it happens. Next slide. So the addition that we added, we said this: if short-term rental property has 4 or more complaints throughout the year, we have the right to revoke their permit, right? So the process could look something like this. The first one could be too many cars in driveway, for example. We open a case, we investigate it, we'll contact the property manager or the property owner. Even though we fix it, we still count that as number 1 violation for the year. The second thing could be loud noise. Same thing. We'll go. It could happen overnight. Police officer will go to the property, and we'll verify the complaint. And when we're talking about complaints, we want verified complaints. One of our officers went out there, confirmed the complaint, or in some cases we could get affidavit, but we would rather have one of our officers go out there to confirm the complaint, just to be fair and to be sure about what exactly is going on. It could be a party in the front yard, right? Too many people. It could be failure to apply for the permit or pay for the permit. So any combination of those 4 complaints or violations will result in the city to revoke their permit. What happens if we revoke their permit? We have the right to revoke the permit, but residents have the right to appeal the process. And that's where your role comes in. And our city attorney will talk a little bit later about exactly how the role happens. Next slide, please. The way we wrote the ordinance, the appeal process works like this. The homeowner can file an appeal. The Board of Adjustment will conduct a hearing. And at the end of the hearing, you either grant or deny the appeal. If you deny the appeal, the homeowner has to wait 6 months before he could apply for a new permit. And all decision that you make will deem final at the city level. So the process is pretty simple, basically 3 things. You file an appeal, we conduct a hearing, you either deny or grant the appeal. Next slide, please. Second thing that we improved is registration requirements. Next slide, please. How do we improve that? Initially, we used to ask for items from 1 to 6 on this list. We asked for information about who's the property owner, who's the primary residence, who's the local contact in case if we need to talk to somebody, what's the floor plan, right? And now what we improve the process, we ask the homeowner that wishes to rent his home for short-term rental to submit a complete list of all rentals advertised in all hosting sites. We need this information because we need to determine, is this homeowner running a business out of his house or just supplementing his income? Because when we wrote this ordinance, we required people to have their house as a primary residence before they list their home on Airbnb or other platforms. And once they come into the process, we will physically hand them this ordinance, letting them know if 4 more violations happen throughout the year, we will revoke the permit. You have the right to appeal the process, and this is how you appeal it. Next slide, please. Third thing that we improved is our neighborhood outreach. How did we improve that? Next slide, please. Originally, what we used to do when we have a short-term rental come through the process, we would notify people within 100 feet from that house. Now we increased that distance to 200 feet. And you could see how when increasing the distance, we're informing more people. Why is that important? It's important because once we notify these residents around the short-term rental, we are providing them with information about if that house violates these rules, that's who you need to call. We have a 24-hour hotline that is answered by a real person, not a machine, a real person, and we'll get back to you. Overnight, they will call the police department, and during the day, they will call code enforcement. 24 hours will answer that. Second thing, once we go out there, we start counting those violations. Is it number 1, 2, 3, 4? If we reach 4, we will revoke their permit. And we even improved our process a little bit more. Now, we let all our police officers know about those short-term rental around the city. We flag those homes, so when they respond to a call, the police officer know they need to call code enforcement so we could start the process of counting those violations so we could know if we need to revoke their permit or not. Next slide, please. A little bit summary, for the foundation of our short-term rental. The foundation, we build it on this. No more than 2 adults per bedroom, and plus no more than 2 additional guests. There shall be maximum occupancy of 10 persons per house. Bedroom under 120 square feet shall be limited to only 1 adult. Maximum 1 car per bedroom. And any advertisement of the property, online or offline, and all rental contract must contain a language that specifies the allowed maximum number of occupants and maximum number of vehicles. We believe by improving those 3 foundations, the registration process, the enforcement, and our neighborhood outreach, we are able to serve both sides of the equation, people who wish to rent their home and people who wish to protect their properties from short-term rental. So your role becomes, if we get 4 more violations, we will revoke the permit and they have the right to file an appeal. And our city attorney, Bob Hager, will go a little bit over exactly how that process looks like. But before I hand it back to him, do you have any questions for me?
So if you don't mind, what you just went over in this last slide here, is that the synopsis of the city ordinance as far
Correct.
as the ability to obtain a permit?
This is basically almost a summary of the foundation of our short-term rental ordinance.
Okay, that was one of the 3 items, and so you chose to go with regulation. When you started out, you said, just leave it alone, regulate it, or I can't remember what the other third one, the option that the city had proposed to you.
Correct, sir.
Right. Yeah.
Right.
Correct. We are, the city council give us their guidelines that we need to regulate short-term rentals. And this ordinance is a result of that direction.
Great. Thank you, sir.
My pleasure.
So I have a couple questions. When it comes to the car limit you have here, how do you know which cars, because so there's a short-term rental across the street and a couple houses down from me, and a lot of the people who live on this street will park their cars on the street in front of their house, and cars will park in front of that short-term rental. It's not always clear whether the cars belong to that short-term rental house or they belong to a guest of one of the homeowners at a different house. So would the people around the short-term rental just kind of have to guess, call you guys, y'all come out, knock on the short-term rental door and say, hey, how many cars out here belong to people in this house? And if it's more than 3 or whatever the limit was, then you cite them?
Absolutely. There's investigative process that goes into it. A lot of times when we hear a complaint, we send, an inspector, or we'll send a police officer, and we have to do our due diligence by, inspecting the facility and just making sure that those cars belong to this address. And a lot of times when you have 3 or 4 or 5 more cars, it indicates that they have a party house, which that violates the foundation of Airbnb and other platforms because they prohibit those venues.
And what about the bedrooms under 120 square feet shall be limited to only 1 adult occupant? I mean, how do you know how big the bedrooms are in these houses? We
do ask them to submit a site plan before they come to the process. And since we work in the building department, a lot of times we have access to some of that as well. But they are required to submit a site plan. Gotcha.
And then my last question is, when you say if somebody calls to complain, officers will come out, do you mean the code enforcement officers or PD? And does code enforcement work weekends?
It could be both. If it's after hours, a lot of times it's a police officer that's going to go there, right? And that's why we flag those addresses in the system. So the police officers, as they respond, they know they're responding for a short-term rental, so they could communicate to us the next day. Or a lot of times they communicate to us the same day.
Gotcha. Thank you.
My pleasure.
I have a question.
Yes, ma'am.
Are the property owners required to still live at the property and like they just rent out for short-term rental bedrooms? Is that how this works? Or they can use their whole house as a rental property?
I mean, they have to have their house as a primary residence. A lot of times what they do, they either rent, 3/4 of the house or they leave the house for the weekend. So, but that house has to be their primary residence. So when you check their identification, it has to say that home on it.
Yeah, Michelle, this is Bob. They're both. We have some that just rent a bedroom, some that rent the whole house. They're supposed to be owner-occupant. In Coppell. Mm-hmm. There's some case law that's out there, basically emanating out of Austin, that has said that may be unconstitutional, but we're being aggressive in this regard. We want owner-occupant. We don't want our neighborhoods turned into mini hotels. And I would argue that if you're buying up homes to use them for the sole purpose of renting them out through Airbnb or some other management company as vacation homes, you're just running a hotel in a residential neighborhood.
Okay, thank you.
And how do y'all make sure that the owner is actually living at the location? I mean, they could easily get that on their driver's license, but not actually be living there. So how's that monitored?
Yeah, it's difficult, to be honest with you. However, we have a number of people that own a home in Coppell, and we don't believe that they're residents of Coppell, but actually reside in another city. And it's an ongoing, it's not easy to prove. There's a homestead exemption we can check. There's state records that we could check to see if they've actually living in another place. The loophole would be that I could have a long-term lease with, just say I own the home, I enter into a long-term lease with you, Ms. Grubb, and then you turn around and lease the house out. As a long-term owner, or as a long-term renter, you have kind of similar status as a resident. It's not without peril, but we think that this is the best we can do with how the courts interpreted the law right now. So we're taxed with doing that, but we're trying to be as vigilant as possible. Hopefully we're going to get some help from the legislature on this issue because the court is fairly hostile to our regulations, to be honest. They think that it's an impairment of people's ability to do what they want with their home. I would argue that when I bought a house in the neighborhood, I didn't buy it next to a hotel or motel. I bought it next to someone else who would live there most, if not all the time, and might occasionally have a party. That's fine, but not every weekend. So we've been a little taxed by this, and the court's not helping us a whole lot, but we're going to stay as aggressive as we can within the bounds of the law.
Just for edification, I agree with your assessment, sir.
Yeah. It's a problem. Fortunately, it's not, we only have 11 of these. I think 4 of them, if I'm not mistaken, are just single bedroom rentals, not the whole house. We have a couple that have been very trying. The reason we come up with 4 is our number is we've had a number of, there's been a couple of places that are chronic violators. And with the pandemic closing a lot of bars and restaurants, what became real popular last summer was to rent a house and basically turn it into a nightclub 1 or 2 nights over the weekend. And we had problems with those places. If you would see the tapes of the party going on there, you would be upset. There was lots of people, and I won't say the name of the university, but apparently the 5 or 6 members of a college football team rented the house for the weekend, and you can imagine the craziness that went on there. And in that case, we actually had videotape because one of the property owners had a security camera. So you may see that if we have a repeat of that house. Mr. Raheel, are you ready for me to do my little presentation about
Yes,
this?
please.
Okay. As Louis has discussed with you, if we revoke a permit or deny someone a permit, they may appeal that based on this complaint, based restriction on the use of the Airbnb or the house as an Airbnb. And what that would basically entail is it would look very familiar to you is we would attempt to present the case as we do a variance case or any interpretive case that you exercise your discretion that we talked in earlier. Basically, you would staff would receive the appeal. Then I would assume that Ms. McGee would then contact you and say that we're going to have a hearing under this ordinance and notify you of that. And what I'm going to do is kind of go through how I think this hearing would go forth and what you would be expected to do and the rules. And then if you and the rest of the board would like, I will reduce these into writing and you can adopt an order on the process so that you've got a guide. And so whoever the property owner is knows what's expected of them and how this is going to proceed and give you some guardrails to conduct this hearing. So after you've received the notice and we would set the hearing, the chairman would call the meeting to order, and that anyone who was going to present any kind of evidence, be Mr. Raheel or Ms. Arnold or someone from the zoning staff. They would get sworn in along with the owner and any witnesses. We would anticipate that we will have neighbors come in and testify about the facts and circumstances of the guests' behavior at one of these short-term rental facilities. We obviously are not out patrolling every neighborhood every night to determine whether or not the Airbnb or the short-term rentals are being operated in an appropriate manner, but rely on our neighbors to call us and tell us that there's a problem. So we would anticipate that there'll be neighbors who would come and testify about the conduct of people that were at the facility, the cars, and the other behavior of people that were utilizing the Airbnb. So as you know, the people within the 200 feet, I'm going to make a recommendation that they get a specific notice that there is a hearing about revoking this particular permit that the city has granted to operate the Airbnb, to encourage them to show up, and they'll know when to show up. Most of the people that have issued complaints stay in touch with staff because they want some relief. And if there's a problem, we're going to be familiar with them. They're going to be familiar with us. So we make sure that those people appear before you and present whatever pictures they may have taken, whatever tapes they may have from a security camera, and any evidence that they may have about the conduct of the owner of the home. The staff would present our case. We would tell you that here's a copy of their permit. Here's a copy of the police offense reports that we've received as a result of the operation of this house as an Airbnb. And I will tell you that we have met with the police department and Chief Barton and his staff, and have educated them on the ordinance and gone through the tapes and the various complaints that we've had. And we're going to get a lot of cooperation out of our PD to answer those off-duty hour calls. Many times when we receive these complaints, they are on either a Thursday night, a Friday night, or a Saturday night or Sunday morning, however you want to view that. I noticed the one thing that Airbnb has done is that they now require you to rent the home for more than one night in order to avoid this one-night party on a Friday or Saturday. So they make you now rent the home for Friday, Saturday, and Sunday. So it makes it a little bit cost prohibitive just for someone to come in there and younger adults to rent the house for just one night to have a party like this. So we've had some cooperation from the advertising entities that promote these kind of uses. We would obviously present staff, neighbor witnesses. We'll have whatever photographs, videos, letters, and offense or incident reports from our police officer. And then I would assume that Mr. Raheel or Ms. Arnold would ask you all to revoke or uphold, deny the appeal, and uphold the revocation or denial of that license. Correspondingly, the property owner will be given a fair opportunity to present their case as well. They can present whatever witnesses, photographs, rental agreements, other evidence that they have that these complaints were not substantial and that the revocation was inappropriate given the nature of the complaints. I think it's fair to the property owner that if you had a spite neighbor and they called and complained, even though there wasn't an offense, our staff is going to go when we get the call. And just because there's a call doesn't mean there was a violation. That's why we're going to do the incident reports, and why code enforcement, that officer, be it a police officer or code enforcement officer, is going to testify as to what they found and what the nature of what they found and whether or not it was egregious or not, so that we're not unfairly treating our own residents. After the presentation of that evidence, the property owner will be given an opportunity to make a summation, and our staff will be given the opportunity to make a summation. After that, you can deliberate, you can review the evidence just like you do in a variance case. You can ask whatever questions you want of any of the witnesses that you deem appropriate. And then you can make a motion, and I'll always ask you to make an affirmative motion to either deny the appeal or uphold the appeal. My preference is obviously a motion to grant the appeal. If it doesn't receive 4 affirmative votes, it is in effect a denial of the appeal and upholding the revocation. Assuming that you deny the appeal and uphold the revocation, I will produce an order for you for the chairman to sign based on your vote to either grant or deny the appeal, and that would conclude the matter. There is, the way the ordinance is written, the decision of the Board of Adjustment's final. If they do try to go to court, I think that would leave them with the opportunity to do so if they felt necessary, but there wouldn't be a basis for a district court to overturn your decision. So with that, now if they lose their appeal and their permits revoked, they can apply again within 6 months after your ruling to get a new permit. We'll just have to wait and see whether or not the staff would grant the permit based on the nature of the conduct of the property owner, but they may be back to see you again, and you get to judge their credibility once more of whether or not they should get a permit. I would recommend that you adopt basically this procedure that I've just read off to you in terms of an order, and I will do that and I don't need any formal action tonight, just a nod of the head from all of you will be sufficient, and I will get that to Ms. McGee and have her put it on your next agenda for you guys to adopt. And of course, you can change it any way you deem appropriate. I tried to give them at least a basis of due process. They have the opportunity to present evidence, present witnesses, and they'll do it under oath. And I don't expect you to be Judge Ito and have to rule on every objection. But the whole idea is it credible? Is it believable? Is it something that you can base your decision on? If we have a hearing, I or someone from my office will be there as a resource for you to try to keep you out of trouble and try to keep you between the guardrails to make sure that if we are challenged in court that we can uphold your decision. And I'll turn it back over to Louie, or happy to answer any questions.
Thanks, Bob. You've kept us out of trouble for a long time. We're going to expect you to keep us out of trouble. Okay. Are we wanting to vote to adopt this appeal process tonight? Where'd everybody go?
I'd kind of like to see it in writing before.
I think Bob had indicated that he was going to put it on the minutes.
I'll put it on a future agenda for you, and I think it should be in writing, and I think you ought to put your eyes on it in case you want to add to it or subtract from it. I've pretty much written it out, so it won't take very long. I'll try to get that to Cammie. I would also recommend to you all that we'll try to get you a copy of the ordinance, because it was just adopted. The amendments were just adopted less than 30 days ago. So it would be a good idea for you to actually have a copy of the ordinance that the council passed, and we'll try to get that to you as well. I've got it, and I can send that to Cammie and have her forward that to you, and then I'll get a proposed order on the procedures and get that to you within the next week.
Sounds good. Okay, is there any other business? Is everybody out of questions? I'll entertain a motion to adjourn.
I'll make that motion.
Okay.
I'll second.
Okay, Laura seconded. I read her lips. Okay, we're adjourned.
Good night. Thank you.
Good night.
Bye.
Thank you.